Order. Welcome to today's public session of the Justice Select Committee, where the single item of business is the evidence we are going to hear from Stephen Parkinson, the Director of Public Prosecutions, who's been in that role for just over a year. So welcome, Mr. Parkinson. Thank you very much for attending today. And before I perhaps ask you to introduce yourself formally, as we always do, we will go through round the table here for any declarations of interest that members have. I will start by saying I'm a non-practising barrister. I'm a member of the Unite and GMB trade unions, and I'm a patron of the Hammersmith and Fulham Law Centre and also of the Upper Room charity. And if I could start with Tessa Munt and go round.
Thank you, Tessa Munt. I'm a member for Wells and Mendip Hills. I've a full declaration as required, but I would just point out I'm the Vice Chair of Whistleblowers UK.
Good afternoon. I'm Alex Burrows-Curtis. I hold a practising certificate from the SRA. I'm a member of GMB and Unite, and I'm also just an ordinary member of the APPG on whistleblowing.
Sarah Russell. I hold a practising certificate with the SRA. I am a member of USDOR and Community Trade Unions. I am a member of the Industrial Law Society and the Employment Lawyers Association, and I am a member of the APPG on Access to Justice.
I'm Josh Babarindi, the MP for Eastbourne. I'm a non-practising, non-lawyer.
I'm Pam Cox, and my interests are as declared on the register. There's nothing pertinent to this committee.
Good afternoon, Director. My name is Lindsay Farnsworth. I'm the member for Amber Valley. My interests are registered, but of relevance to this committee, I was a solicitor with the Crown Prosecution Service from 2003 to March of this year. I'm a member of the FDA union and a member of the APPGs on Access to Justice and also perpetrators of domestic abuse.
Good afternoon. I'm Warren Just, a Member of Parliament in Wolverhampton West. I'm a solicitor. I've renewed my practising certificate, but not practising at the moment. Member of the GMB, member of the Central Executive Council of the GMB, member of various APPGs, and my wife is a senior Crown prosecutor working in the Russell unit in Birmingham.
Mike Tapp, Dover and Deal, and previously employed by the National Crime Agency.
Thank you very much, everyone. As I said, Mr. Parkinson, we're very much looking forward to this afternoon, and we'll go straight into the questions, but I'll ask you a general question first, if I may, which will give you an opportunity perhaps to introduce yourself to us. Before your current appointment, you spent 20 years as a criminal defence lawyer, and now you're head of the Crown Prosecution Service. How do you feel that your previous experience and previous career has prepared you for your current role, and what have you, what skills did you bring to this role as a result of that?
Thank you for that question, and thank you for this opportunity to appear before the committee. Yes, I spent 20 years as a defence solicitor, the previous 20 years actually in the public sector, starting off as a prosecutor. So in terms of my career, I've spent an equal balance, I think, between prosecuting broadly and defending. I do think that having spent all that time as a defence solicitor, it does give me a more rounded perspective in a number of respects. Certainly it helps with casework decisions. When I was a prosecutor, I always did my best to anticipate likely defences. But I have to say, it was only when I started defending people, and my primary responsibility, apart from my obligations as an officer of the court, was to focus on my client. I saw things I wouldn't have seen as a prosecutor. And so I think it will make me, it has made me a better lawyer. Also, I've seen the criminal justice system from a different perspective. I'm very much alive to the pressures in the criminal justice system, and I've seen it from both sides. Just taking your question and thinking about it slightly more broadly, my last job, I was the senior partner of a fairly large law firm, 500 people, 81 partners. It's a role which meant I had overall responsibility for every aspect of the firm, including marketing, finance, IT, the broad range of things which you don't actually see as a lawyer in practice particularly. You're aware of them, but when you're the head of the firm, they are your responsibility. And I think that has helped to prepare me for the step up to the leadership of the Crown Prosecution Service. I think the other thing I'd say about my experience is I started off my career as a prosecutor, as a frontline prosecutor. I was a senior Crown prosecutor in the Crown Prosecution Service and undertook a number of frontline roles. The roles which are performed by roughly half the workforce in the Crown Prosecution Service. So it's given me a deep understanding, I think, of the work that my colleagues now do. I've spent most of my career preparing cases, either as a prosecutor or as a defender. So I do think it gives me a deep understanding and perhaps a little bit of added credibility when I go around the areas and I'm talking to people.
Thank you very much. And what would you say that the year you've been in post has taught you about the wider criminal justice system, and in particular from your interaction with the CPS areas?
Yes. So I spent the first 6 months, well, a lot of the first 6 months, going round each of the 14 CPS areas. I spent normally 2, sometimes a little bit more than 2 days in each area, spending at least a day with colleagues, but also taking the opportunity to meet chief constables, resident judges. I wanted to get a feel for the pulse of the organisation, also relationships between the various partners locally, the police, the courts and ourselves. I came in with some ideas, and maybe at some point in this session I can talk about some of the priorities I've come in with. But I did a lot of listening as well, as you might expect and as you would probably hope. And I learned a lot about the everyday experience of frontline prosecutors. Lots of frustrations with some of our systems and processes. But if I may say so, and this was a really pleasant surprise, the level of commitment I have found across the Crown Prosecution Service has been quite extraordinary. We do an annual people survey, and these surveys show consistently that our people have a 91% sense of commitment and purpose in relation to the work that they do. These surveys contain plenty of moans and gripes, I assure you. But in terms of the worthwhileness of the job that they do, there's a very strong sense, and it's not just the lawyers, it's everyone in the Crown Prosecution Service has that strong sense of commitment. And I've seen that. I've also seen, and this is perhaps unusual for an organisation whose predominant purpose is the practice of law, I've seen a willingness to be innovative and embrace change. Those of you who are lawyers around the table will know that we can be quite cautious, can't we, as lawyers? But my colleagues are quite open and flexible. And I have seen changes from when I was last in the public sector. Obviously, the service is more digital. It was paper-based when I left. It's flexible, as I think I've indicated. The quality of the work is high. And there's lots more monitoring. So we've got the capability to drill down quite deeply into the performance of each area, but also compare one area to another. These are all quite positive changes from the service that I left 20 years ago.
Given that analysis, what do you think are the key metrics at the moment in assessing CPS performance, and how are they measuring up to that?
Well, our metrics are based around a number of factors. timeliness, so how quickly we process cases, from, in particular, from when we get a referral from the police. And we divide that between what we call red charging and green charging. So red charging is where someone's in custody, where our target is 3 hours to make a decision. And if they're on bail, it's 28 days. So there's timeliness. We also look at our performance in court. And I've been giving a lot of attention recently to our early guilty plea rate. Ideally, we will achieve an early guilty plea, by which we mean a guilty plea at the first substantive hearing. So we monitor that as well. We look at our cracked and ineffective trials, particularly ineffective, and whether that's due to prosecution reasons. We look at how quickly we serve papers, and we look at our timeliness in relation to communications with victims.
Thank you.
One thing, may I just say one thing, and perhaps we'll come back to it, but I want to flag it up now. Something that I noticed when I arrived and talked to colleagues about was the fact that a lot of our key performance indicators are based around process. Mm-hmm. And coming from business, where the focus is on outcomes, I'm trying to do something around reorientating what we do and also what the police do. But perhaps we can come back to that.
That is interesting. My final question for the time being, I have to ask you this. You said that you'd wanted to be DPP from the age of 25. Is that correct? And what motivated you in that way?
Yeah, well, it's true. It is true. It is true. My very first job was actually in the department of the Director of Public Prosecutions. It preceded the CPS. Now, I know many lawyers will disagree with what I'm about to say, but I'm going to say it anyway because I believed it then, I believe it now. I think the job that I do is the most impactful and consequential and worthwhile job any lawyer can do. I've always thought that, and that's why throughout my career it's a job I wanted to do. I gave up on it. In my mid-40s, I applied to become director of the Serious Fraud Office, was shortlisted and was unsuccessful. And I thought that it would never happen, and I went into private practice. And although I was actually offered the opportunity to apply, I never did so, to do with not wanting to let down my firm. But last year I retired, and the opportunity came up, and I applied, and I'm absolutely delighted to have been successful.
Thank you. Mike Tapp.
Thank you, Joe. Congratulations.
Thank you.
I'd just like to touch on the Crown Court backlogs.
Yes. Yes.
In the absence of the official published data,
yes,
what's the CPS's estimate of the size of the Crown Court backlogs, please?
Yeah, certainly. Well, so you are familiar, I know you are, with and I did watch the session with the Lady Chief Justice, so she gave you the published figure and her own figures. I should say that we count cases differently to the court service. So we count defendants, whereas they count cases. So you appreciate that a case will involve more than one defendant. So our figure for the Crown Court backlog is, with caseload, is 82,000. And that is 85% above pre-COVID. So a very, very significant rise in the last 4 years.
Thank you. And how far into the future are the trials being listed?
Well, we're hearing that some trials are being listed into 2027.
2027.
Yeah.
What sort of impact for the CPS are these backlogs and delays having?
There's two primary consequences from a backlog. One relates to defendants and one relates to victims. If I can deal with defendants first, some, I'm afraid, are taking advantage of the delays because they know that, you know, the longer the case goes on without being tried, the greater chance that something might go wrong, and in particular that, you know, victims or witnesses will no longer be prepared to support the process. So that's one thing about defendants. The other thing about defendants, I should say, as a former defence lawyer, is that there's a human cost for everyone, whether they're guilty or not. The fact is that a situation has been unresolved. Some of those individuals will eventually be acquitted. Those who will be found guilty have nonetheless had this uncertainty hanging over them. And it one sometimes forgets about the impact of the backlog. But coming to the second part of this, victims and witnesses. So in private practice, I spent 20 years acting primarily for individuals. A few companies, but many individuals. And for those caught up in the criminal justice system, the prospect of the criminal proceedings is like a dark shadow hanging over their lives. Time stops still for many people. They can't get on with their lives. It can affect relationships. It can affect their health. And in terms of the support that victims and witnesses are prepared to offer, there is increasing attrition. And you'll have seen some of the figures. I'm sure it is difficult to keep victims with us. And if they get prepared for a trial, and that trial then has to be adjourned, it often takes considerable courage to gear yourself up for a hearing, and the disappointment is obvious. So what I'd say is that, of course there's a sort of financial cost to backlog, and it impacts not just victims, witnesses and defendants. It affects my own staff, it affects the bar. But there is a human cost. And I wanted at some stage to talk about my priorities, but my highest priority is to reduce delay, do what we can to reduce delay and to influence both the police and the courts in that respect as well.
And your target of 3 hours in custody, and I think you said 28 days on bail, are you meeting those?
No. We're getting better, but we're not. It's for bail, it's around 83% in respect of the areas, and it's something similar for custody. But we are getting better. We have. At the same time as rolling out by the way, if those figures are wrong, I'll get back to you on that. But in rolling out red and green charging, it was part of an overall project to improve the way the police and ourselves cooperate on charging. It's been rolled out for about a year, and we are seeing an improvement in those figures. I mean, the targets we set are aspirational. Rather than targets which are easily met. But we are putting a lot of effort into it, and we are moving the dial in the right direction.
And on the Crown Court backlogs, from your perspective, what's the factors that are sort of causing those delays in the system?
Well, there are a number of factors. I mean, the overall position in relation to trials is that on any one day, on average, only 40% of trials are effective. That's on the day listed for trial, 40%, 4 out of 10 cases. And the remainder is split broadly between cracked trials and ineffective trials. So cracked trials, for those of you who don't know, are trials which end up as a guilty plea, having begun as a not guilty plea.
Mr. Parkinson, I'm very sorry. I'm going to have to interrupt you because we have a division.
Oh, right.
And so I'm going to suspend the committee for 15 minutes. and we will resume then.
Okay.
perspectives on why the backlogs are there.
Well, I will... Republic. Okay, thank you very much. Mr. Parkinson, I'm sorry about the interruption for voting. It's one of the occupational hazards we have here. I'll let you continue your answer.
Thank you. So we were talking about the reasons for backlogs, and I was just explaining that only 40% of trials in the Crown Court actually take place on the day that they are listed to take place. And that 60% that don't happen is pretty much evenly split. I can give you the detailed figures if you like them, but between cracked trials, which is that's the expression for trials that end up as a guilty plea that began as a not guilty plea, and ineffective trials where for one reason or another the trial can't take place. For instance, if more cases have been listed in the court than the court can accommodate, or if a victim or witness doesn't appear, or if there hasn't been cover in terms of advocacy cover. Those are certainly factors that cause the backlog. And historically, there's always been a backlog, but in the last 4 years, the backlog has grown considerably. And going back to the question that you asked, and that's been a combination of factors. It's been the overhang from COVID, the overhang from the bar strike, but more recently, the fact is that there have been many more receipts, that is, cases coming in from the police and then the Crown Prosecution Service, than the court can accommodate by way of finalisations. And so the workload is growing, but the capacity of the court to deal with it has remained the same, and so that's adding to the backlog. Can I just, while I've got the floor, can I just correct a figure I gave you earlier, just on, because I've now looked up those figures on charging timeliness. Mm-hmm. So I gave you 83% we're meeting for in red cases when that's dealt with within the area. If you include the area and our out-of-hours service, it's 67.3. In terms of the bail cases, the green cases, it's 61.6. So, you know, a lot of work to be done to improve those figures, if I'm absolutely honest. But it's partly a consequence of the pressures that we're under in terms of the receipts coming in, and that comes back to what I was saying about the backlog as well.
Thank you. And the receipts coming in, what's the reason for that increasing, would you say?
I think primarily it's a consequence of the fact that the last government increased by some 20,000 the number of police officers. It was a commitment to the last government, and that's feeding through into casework. And we expect that to continue, so we expect workload to grow by around 10% next year. The other thing just to say about that is something like 38% of the police force are less than 5 years service, so they're quite inexperienced, and actually something like a third of our own people are less than 5 years. There's a lot of inexperience in the criminal justice system, and that means it takes longer to deal with cases. The police haven't got the experience to be looking for the right things. There's often gaps in terms of what they send to us, and sometimes our own people are a bit too cautious actually about the decisions. They could prosecute, but it's tempting just to ask for a bit more information. It's something that I've discussed with the police. We're all alive to. If we can keep our workforces, then it's a problem which will hopefully reduce over time as they become more experienced. I sometimes compare the performance of our colleagues in the CPS areas with CPS Direct. It's our out-of-hours service. They're on duty from 5 o'clock in the evening till 9 o'clock the following day. They're quite experienced people generally. For one reason or another, they've chosen to be working from home. And they make those decisions. At least the target is to make a decision in 3 hours. And when you look at their overall performance in terms of the conviction rate, it matches the national conviction rate. Now that's partly to do with the quality of the decisions they're making quite rapidly. I must add, obviously there's lots of further work to be done within the CPS areas. But it is just an indication to me that experienced prosecutors can make decisions quickly. And of course, that's just a matter of common sense, isn't it?
I think retention is important as well, isn't it? Do you have an issue with retention at staffing?
Well, to some extent, but not as much as one might fear. So, in terms of our workforce, so our core prosecutor is a senior Crown prosecutor, an SCP, and our turnover rate is 6.7% a year. That's actually below the civil service average. And in fact, our average length of service in the Crown Prosecution Service is 15 years. I came back after 20 years, and I recognised a number of people. So I think that's, if I say so, it's because we continue to be a good employer. We invest in our people. We believe in job development. We want to give people a varied career, and there's lots of opportunities for people. And as I indicated, both as to why I wanted to do the job I'm doing, but also I mentioned those figures, 91%, about a strong sense of commitment and purpose. People want to be doing this job. So we do lose people, but we've got quite good rates of retention.
Good to hear. Zooming out a bit again. So you've said in the past, to deliver swift justice, our whole criminal justice system must adapt and change. Can you elaborate on that, please? And also, what reforms would you recommend?
Yes. It does need to. And obviously I said that and I meant it. Perhaps I can begin by saying why we did so well, if I can put it that way, in the summer. And I say we, I mean the criminal justice system. Because every part of the criminal justice system stepped up. And that was a consequence, I think, of a shared recognition that we were in the middle of a national emergency. And that required an extraordinary level of commitment, by the police, by ourselves, and by the courts. And people did. I mean, they worked 3 weeks at a stretch, very long hours. And that's something you can't do as business as usual. Unfortunately, you can't work at that pace. So I'm often asked, why can't we just carry on doing this? And we'd love to, but you can't carry on at that pace. But we are wanting to learn lessons from this. My personal view is that, the level of cooperation and coordination across the criminal justice system has never been better than it is. And I think that was shown over the summer. But we all know that the problems across the criminal justice system continue to be endemic, and we can't just keep doing the same thing over and over again and expecting a different result. So we need fresh thinking. I think there's some systemic changes that are needed. The new government has extended magistrates' court sentencing powers to 12 months, which will make a difference. I think the feeling is it will save 2,000 sitting days. Some thought needs to be given about reclassification of offences, potentially. And from time to time, there is discussion about having intermediate courts. Intermediate courts would involve perhaps a district judge sitting with 2 lay magistrates with capacity to sentence up to 3 years. That would all take work out of the Crown Court. So that those ideas have been canvassed, and they're certainly worth exploring. There's one thing that you may have seen, because I've been talking about it recently, that I think has got a huge amount of potential, and that is in relation to guilty pleas. So 70% of cases going through the Crown Court end up as a guilty plea, but only 36% of cases are a guilty plea at the PTPH, the first substantive hearing. So I was talking to the Recorder of Manchester a couple of weeks ago about workload in his area, but I think it's quite typical. So he said there's an average of, I think, 8.7 hearings per case. But even for a guilty plea, even for a case that ends up guilty, it's between 5 and 6 hearings. So if we can squeeze out the guilty pleas at a much earlier stage, we'll save 4 hearings. So one thing we're doing is we're serving our case, our full case, for the first substantive hearing, the PTPH. But it's not having the effect that we would like to see. It's nudging up that early guilty plea rate, which is one of the key performance indicators that we were talking about earlier. It's nudging it up a bit. But there's a couple of things that I think I'm thinking about, which could be transformative. One is to take something which is already present in the Attorney General's guidelines dealing with serious and complex fraud cases, which enables prosecutors to proactively have a conversation with the defence. Generally, the rule at present is that you wait for the defence to come and approach you. But under these not very well-known guidelines, frankly, I'd never come across them when I was in private practice, even though I was a white-collar crime lawyer. Prosecutors are able to proactively have that conversation, and where it's possible, agree a common basis of plea in terms both of the facts and a common understanding as to to where in the sentencing guidelines, if there are any, the case should land for the judge. So to take an example, violent disorder over the summer, there are sentencing guidelines on violent disorder. Most cases came into category B1. It was quite easy. I looked it up over the summer. I thought, oh, that's a B1 case. Most of the cases were B1 cases, and they ended up as a 2 to 3 year sentence. So it's quite possible, both for the prosecution and the defence, to look up guidelines and reach a common understanding as to the appropriate sentencing range. So my first thought is, if we can have, in appropriate cases, and obviously with due consultation with victims, a conversation with the defence which enables us to go to court with a common understanding, that might give defence lawyers and their clients the confidence to put forward a guilty plea with all the discounts which are available as a result of an early guilty plea. But the other thing which I think really does require attention is around payment for the defence. So I've been talking to Richard Atkinson, who's the new chair of the Law Society, around this issue. And it's not, this isn't new, it's something which is commonly understood, but let me explain it. If as a defence solicitor, my client pleads guilty at the PTPH, I get a guilty plea rate, fixed rate. If my client pleads not guilty, but at a later date pleads guilty, I get a cracked trial rate. The cracked trial rate is substantially more than the guilty plea rate. So, and it's even more notable with barristers. So, to give an example, Class A drug supply, guilty plea fee £639, cracked trial fee £815. That's a 27% uplift. Burglary, 212. Crack trial, 267. For barristers, the difference can be 100%. So for Class A drugs, 3,370. Guilty plea, 6,739. Crack trial fee. Burglary, 460. Crack trial, 920. So the consequence I draw, the conclusion I draw from this is that we're not incentivising the defence to give early attention to papers. And what I'd like to do, but obviously it's not within my power, but I'd like to talk to those responsible who
One of the questions I have is who sets those rates?
Well, they're set in criminal legal aid regulations, and obviously they're the primary responsibility of the legal aid agency. So it is an issue I'm raising. What I'd like to do ideally is to have some pilots where we can just look at this and see what effect is had by maybe 3 pilots, one involving my early conversations plus an additional fee, maybe another pilot with just my conversations, and then another one with just the fee. Let's look at it. But you can see the potential when you come back to what I was saying about 5 hearings for a guilty plea. So anyway, I mean, sorry, it's a long answer, but I'm coming back to your question around, doing things differently. If we don't start doing things differently, the problem's going to just get worse, I think.
That's really, really interesting, actually. Thank you for that. Is there any other questions on that point? Otherwise, I'll move on.
Yeah, can I volunteer Bristol?
One of your pilots. Moment. I've had Lindsay indicating for a long time.
Sorry.
So Lindsay Farnsworth, if I can bring you in.
Thank you, Director. I want to take you back, if I can, to the red charging cases and green charging cases, but really look at the red cases. So I think you said that the target is 3 hours for a decision, and I think you said it was an 83% success rate overall, but when out of hours was taken into consideration, it drops down to 67.3%, I think you said?
Yeah, that's right. So 83% if it's the area only.
And I think you talked about the attrition rate being actually good for those out of
conviction rate
for the CPS direct lawyers, essentially. So the results are good, but the timeliness is going down when out of hours charging is taken into account. Now, as a disclosure, I worked for CPS Direct for 5 years. So why is it that the timeliness goes down when out of hours is taken into account?
I can't give you an accurate answer now because it's something I'm looking into. I only became aware of that drop compared to areas relatively recently, and so I'm asking questions around this. If it's a question of staffing, then we need to adjust the staffing. What we do with CPS Direct is we allocate staff according to peaks and flows. So our experience, and you may well recall this from your own experience in CPS Direct, there are a few hours towards the end of the day, probably between sort of 8 to 11, 12 p.m., where the pressures are greatest. And so we deploy more staff at that point. So I need to look at that whole issue around whether we're resourcing this adequately. But there are other factors which affect the efficiency of CPS Direct, and this concerns sort of police behaviour really, because ideally CPS Direct would get a reasonable notice that a case is coming in, and they'll get the full 3 hours that they need. But some police forces, for one reason or another, actually approach them when the clock is ticking well within that 3 hours, so that they might just get 1 hour to deal with the case, or just slightly more than that. The problem with that is it then pushes other cases further back, because that then becomes a very urgent case, because the pace clock is ticking away. So
your 3 hours isn't the pace clock, is it?
No.
3 hours is your target. So when does the clock start to run for the 3 hour target?
Right, I'm confusing you. By the way, I'm explaining it. Forgive me. So there's two targets. There's our target, which is the 3-hour target. There's the pace clock. So when I say that there may just be an hour or an hour and a half left, I'm talking about the pace clock. So the impact of receiving a case late from the police is that we have to deal with that as a matter of urgency. And then that pushes back our ability to deal with other cases in the system, which we could have accommodated within our 3 hours. Our own internal target of 3 hours, and we miss it. That's one explanation that I have been given quite often, actually, and it's a consequence, I think, probably of the, of the pressures that the system is under. But it's something that I have asked questions about, and I am looking into. I should explain, just to contextualise all this, that so red charging, that is charging of people who are in custody, happens out of hours, but it also happens during the day now, and within the areas, and the area performance is better. Our different areas across the country are subject to different pressures. What we have done relatively recently to address that fact, 2 years ago we created a central prosecution team. And recently we have doubled the size of that team. So there's now 17 people, we're heading towards 24. But they are able to deal with areas under particular pressure. So in the last 2 years they've done 9,500 charging decisions. And because we're a national service and we have uniform practices and we work online, we can deploy people across the country to do that. So a question I've actually asked when I looked at these figures very recently was, right, so we can manage that in the areas. We need to be looking at whether we need to do more with CPS Direct in order to address those figures. So I'm looking at it, but I'm sorry I can't give you a better answer.
3 hours start from the moment the police phone CPS Direct? Is it still a phone line system?
No, I think it's from the point at which it gets to triage, when it's accepted by us.
I remember long queues of officers waiting on the phone for it to be answered, and I don't know whether that's still the case.
Well, it shouldn't be. We've now rolled out this charging model, which you may recall from when you were in the CPS, and part of this is to improve the transfer of files between the police and the CPS, so they should no longer be hanging on the phone. So London came on stream over the summer, and actually it turned out to be quite a smooth transition, I'm glad to say. I'm sorry, can't remember which area CPS you worked in, but that certainly was a feature, and hopefully it'll be a feature that no longer is with us going forward.
Thank you. Sarah and Tessa, do you still want to come in? Sarah?
Yes, so apologies, this may demonstrate that I don't fully understand the criminal justice system, but you mentioned 5 to 8 hearings to get something to a full trial, and obviously reducing cracked hearings would reduce that. But apart from that, is there nothing that could be done to consolidate that? I know it's more complicated than an employment tribunal, but an employment tribunal, as standard, even for quite a complex discrimination claim, you would have one preliminary hearing to establish the pathway to a full hearing, and you might have one more hearing to deal with a specific issue, and then you'd have your full hearing. So I'm wondering what the scope is to, instead of this being 5 to 8, it to become 3.
Yes, well, it's a very fair question. There's a body called the Crown Court Improvement Group, which consists of the police ourselves, judges and so forth. And the senior presiding judge, Lord Justice Edis, who was the SPJ until recently, put out some listing guidance, actually in January 2023, as to the ideal length of number of hearings that might take place. There is an extra hearing that you wouldn't get in the employment tribunal, which is sentencing. But including sentencing, the guidance he gave was that ideally 5. and I know that's more than your 3, but there are some essential stages. There's the first hearing, which is number 1. There's the trial, that's number 4. Number 5 being sentencing. The recommendation is for at least 1 hearing prior to trial to make sure that everything's in place. And there's recognition that you might want 1 other to deal with disclosure. So between first hearing and trial, 4 hearings. What tends to happen is that you have a hearing such as a PTPH, and everyone's almost ready, but something needs to be done. And so the judge might then list it for an ad hoc hearing. So you have one of these hearings where something is meant to be done and it hasn't quite been done, and so judges then put in an extra hearing. That is what tends to happen. And obviously the courts are wanting to reduce the number of those ad hoc, unplanned for hearings. The Lady Chief Justice last week referred to a review of listing by His Honour Judge Edmonds, I think. And so he's looking at the whole thing. So there is that plan. Any member of the public can look at this. It's on the internet. It does provide listing guidance. I know Lord Justice Edis spent a lot of time going around the country trying to ensure that those guidelines were adhered to, but for one reason or another, it isn't always possible.
Thank you.
Yes.
My point was marginally flippant, and that was when you're running your pilot. Could I offer a conversation with Bristol first, please? Because I think they're feeling the pinch of closures, and if there was a way of easing some of the troubles, it would be good.
Well, I've met the resident judge of Bristol, a hugely impressive judge, if I may say so.
Indeed.
And I'm sure he'd be very open to a pilot of this kind.
And you've offered us a number of ways to perhaps reduce backlogs and delays. When the Lady Chief Justice gave evidence last week, she particularly focused on sitting days.
Yes.
And the effective cap on sitting days. Is that an issue for you, CPS, and how far do you feel that has determined the rate of progress this year in particular?
Yes, it is an issue for us. So our estimate is that between now and April there will be 33,000 sitting days remaining. That's about 3,000 less than we expected, so that's about 10% less sitting days than we were expecting. So it does affect us. I mean, she gave you some specific examples of cases that have had to be adjourned as a result, and I adopt those. They're good examples of the actual impact on courts. The pressures on us are going to be felt most acutely in London, the northwest, the southeast, Wales and the southwest. So there's 14 CPS areas, and I've called out 1, 2, 3, 4, 5, where we're going to feel the pressures, particularly.
I'm keen to move on to a new topic. Anything further on this before we do move on? Are you? Okay. In which case, I will go to Pam Cox.
Thank you for joining us, Director. You mentioned that your highest priority is to reduce delay, and we've been talking about mechanisms that might help with that. And we also know that outdated technology or lack of technology contributes to delay. So I may focus my questions on that area.
Yeah.
CPS had a budget allocation of 49 million this year. Can you give an indication of how that will be spent on improving technology, data?
Yes, well, we haven't yet sat down to work out the detail in relation to how we'll use that extra money, but I'm certain that part of it will be used to improve technology. I mean, there's 2 aspects to this. One is improving our existing systems, So our case management system is 20 years old. And over time we're gradually replacing that. In fact, we've got a 7-year project to do that. But when I go around the country, I come across a lot of frustration in relation to our technology. So that's one part of it. And we are using part of our resource to make improvements. So there are a number of things that we have been doing. We've had money from the Treasury, which we hope will continue, which means that we'll be able to have digital jury bundles. So we'll be able to give members of the jury an iPad. That's going to be transformative, not only for their experience, but in terms of saving our time. Having to rework a paper bundle because council wants to take something out or add something in is unrewarding work and very time consuming. We've introduced email automation, so our staff were having to move emails coming in from members of the public and then manually slot them in the appropriate place in our systems. That's happening through technology now. Witness expenses have been automated. So we are making improvements as we go along, but the frustration is very real. And we will spend some of the money on continuing to do that. But the other area where there's huge potential is around AI. Not only in terms of the existing money that we've been given, but we've got phase 2 of the spending review bid coming up. And one part of that is we'll be making a bid for more technology to make us more productive and efficient. I don't want to give a very, very long answer, but there's more I could say on that if you've got a follow-up question.
I follow up. Thank you very much for that. And I think my colleague would be relieved to hear about the jury bundles, which we talked about earlier. In terms of the common platform, is that the 7-year programme that you'd referred to, the 7-year programme of change?
No,
were you referring to something else?
No, I was referring to our case management system. So it's our internal system. The common platform was meant to be a system which was to be used by all parts of the criminal justice system.
Is that ever going to happen, do you think?
Well, it's been implemented in the Magistrates' Court, and there are some aspects of it which are being used in the Crown Court, but the main use is probably not going to happen now in the Crown Court. It's been used in other parts of the court system. We fully engaged with that project, but we realised 2 or 3 years ago that there were some operational risks in terms of the interplay between our system and the design of the common platform. So we adjusted the way we would operate. So we're integrated with the court system, but we're not part of it in the sense of being one whole system.
And on that question of integration of criminal justice data and systems, are there things that you think the CPS could be doing to assist there? Because in many ways you seem to be ahead of the curve.
In terms of data, definitely. So I think in answer to an earlier question, I said that, for instance, we count defendants and the court service count cases. There's a lack of consistency across the criminal justice system in the way we deal with figures. And a lot of work is going on, and we're closely involved in that. We're a core part of this to actually evolve a common way of managing data across the system. It's obviously very good for transparency, but it will also help us to frame policy. So I don't know, if those of you haven't yet come across it, I would commend the Criminal Justice Dashboard. It's something that I look at often. But even there, you can see that there are inconsistencies between the way the different agencies deal with figures.
Thank you very much. Thank you.
Okay.
So I just sort of follow up to that. We have heard that the CPS is ahead of the curve in some respects in relation to digitisation of data, But I think what the public will care about is that the whole system joins up. And most people, whether they work in the public or private sector, would expect the different systems that they use through an organisational process to all be compatible with each other. Why doesn't that happen in the criminal justice system?
It's because we're not one organisation. I mean, we are. There's 43 different police forces. Each, they are empires unto themselves. We're quite fortunate that we're a national prosecuting service, but we're independent from the police. We're independent from the courts. The courts service sits under the Ministry of Justice. All these systems have grown up over time. And we're working really hard. So we're working with the police on something called the digital case file. And it's a project that's been going on for some while. But within the police service, there are 3 different companies working on producing a digital case file. So it's really quite difficult.
Who do you blame for this?
I'm not blaming anyone. We have got 43 different police forces, and they do have their own governance arrangements. We have a fair amount of joint governance. So having moaned a little bit about the fact that we are where we are, I do need to say that the criminal justice system is becoming more and more joined up. So on police CPS data projects, there is joint governance there. So we do our best between us to manage that. There are all sorts of bodies across the criminal justice system. There's a criminal justice board which oversees the whole of the criminal justice system. Beneath that, there's a group of senior officials, of which I'm one, which is the Criminal Justice Action Group. So we do our best, but what we are doing is we're managing the fact that there's obviously a strong desire for coordination, but there's a level of independence as well. And it's easier for us, in the CPS, because we're a national organisation. But while we continue to have 43 police forces, each with their own police crime commissioner, notwithstanding the best efforts of the NPCC, which is the sort of coordinating body for police forces, they can guide, but they can't command.
Okay. Sorry to interrupt. I think we're going to go on to staffing matters. Lindsay.
Yes, I'd like to talk to you about staffing, if I may. You've talked about, I think at the very start, you talked about the commitment of the staff and how impressed you were when you became DPP. Yes. About the commitment of the staff. And you've also talked about backlogs of cases and the negative impact that has on defendants and on victims and witnesses. But what would you say the impact of significant court backlogs has on the staff within the CPS?
It means they're under considerable pressure. Our sickness rates are a worry. We do have wellbeing support available for individuals, but I paid a visit recently to the northwest area, which is Manchester. I'm on my, I think I said in answer to an earlier question, in my first 6 months I went around every area. I'm halfway through my second round of visits actually, so I went back to Manchester. In the 8 months or so since my last visit, their workload had gone up 30 to 40%. The average caseload for a prosecutor there is 200 cases. I spoke to the chief constable and the deputy mayor who's responsible for crime. And I said, this is unsustainable. And a lot of those cases will be in the backlog. And so, you might say there's nothing to do with them, but of course there is. The fact that you've got a case which isn't coming to trial for 2 years, there continues to be a need to maintain that case. Queries will come in. There's the constant concern that victims might withdraw. So you have your current caseload cases where you need to be making decisions, but there is an element of managing those cases which are in the backlog as well. So it's something that concerns me a great deal. I haven't talked about all the things I'm wanting to do to address this, but can I take this opportunity to mention a couple of things? One of them is a big efficiency project that I have launched. It's on the back of my experience in private practice. And it's a continuous improvement project. What we're doing, and it does address your point about pressure, because the outcome of this, I think, will reduce pressure on staff. So it's an end-to-end review that I've launched, which looks at every part of the process, from the point we receive a case from the police all the way through to sentencing. And it's a project which engages the people who are doing the job on the ground. And basically what we're doing is we're asking ourselves 3 questions. Do we need to be doing this? Can we do it better? And can we do it faster? And the first part of the process is to be asking those questions, mapping, to use the jargon, mapping the process. And then on the back of the feedback we're getting, we're going to redesign the process, and then we're going to bring in the IT to support that. And IT will be going back to your question, a large part of the answer. Can I just give you an example of the sort of clear thinking that has arisen as a result of this? But also the way large organisations accumulate jobs they don't need to be doing. We want to advise the police early in an investigation. We encourage them to come to us and ask us for early advice. So they come to us, they ask for advice, we give our advice. We then chase them. We chase them after 1 month, we chase them after 2 months, we chase them after 3 months as to what they're doing as a consequence of our advice. And then if we haven't heard from them, we archive it on our system. This all involves spreadsheets and monitoring and so forth. As a result of this project, we're going to run a pilot on this. You can see I like pilots, but the pilot will involve, we've given you advice, case is closed. And we'll see if the world falls in. I don't think it will. But it's a good, if I say so, it's a quite good example of how organisations throw tasks that they don't need.
That task, wasn't that task, those chaser tasks, didn't that come off the back of a target that we had, that you had, when I was there, for finalisation of cases in a timely way? So the chasing had to be done because otherwise you couldn't finalise the case within the time limit that we were targeted to do. Wasn't that... I may be misremembering, and I apologise if I am, but...
Well, I'm talking about early advice, and I think we take the view now anyway that we're not formally engaged at that point. Once the police send a case to us for a decision, then we take formal responsibility for our part of the process, and then we do follow up. But with early advice, it continues to be their investigation, and if they decide to do nothing any further with it, it's not our responsibility. I mean, we can argue about whether that's a good thing or a bad thing, but I'm just giving it as an example of something where we've asked ourselves, do we need to be doing this? And the answer at the moment is no, but we'll test this. But going back to your well-being question, I think that there are too many things that we're doing, and organisations as a whole do, that requires just fresh thinking about whether we need to be doing them at all and whether we can do them better. And I'm hoping that this project will increase our efficiency, but also reduce pressure on our people and increase morale. And certainly when I did this when I was in private practice, that was the outcome.
Excellent.
I've
got some more. Thank you. I'm not sure we would have been arguing on that point, but I think it's useful to know that that's being looked at. The CPS annual report talks about the vacancy rate within the CPS of being 6.3% amongst senior Crown prosecutors in 2023. 2023 to 2024. What steps are you taking to encourage more experienced prosecutors to progress their career at the CPS? So, for example, are you increasing the number of specialist prosecutor roles that are available within the CPS?
I don't know if we're increasing them, but there are a good number. Actually, one of the things I've found when I've gone around my area visits is that often they lose their senior Crown prosecutors to a headquarters role or a specialist prosecutor role. And it's something on my agenda to look at, actually, as to whether we got the balance right. But generally on recruitment of experienced prosecutors, well, can I just contextualise this? There's a real issue around attracting lawyers to practice criminal law. You've heard me say already, I think it's one of the most worthwhile and impactful things that anyone can do. But it's quite hard to attract qualified lawyers into the practice of criminal law. I am glad to say that we're very open-minded around this. So when I go around the country and I hear about new recruits, often we've recruited people who hadn't practiced criminal law. They might have been doing commercial work of one kind or another, conveyancing or whatever, but we've recruited them, and that does involve obviously a cost in terms of training. But I will celebrate this because we brought someone from another area of practice into a relatively unpopular area of practice, which is criminal law. But the other, and this is the really interesting thing about criminal law, it is hugely attractive to people who aren't already qualified. We get between 2,000 to 3,000 applications every year for the 80 places we can offer for legal trainees or pupil barristers, 2,000 to 3,000. I want to increase that to 200. And I think if I'm successful in getting the funding to enable me to do that, that will still mean that it will be 1 out of every 10 applicants. So I think I'll manage to keep the quality of people coming in. As part of our strategy, I think, to grow our own, I think in terms of making a big difference in terms of numbers, the answer has to be growing our own and keeping them. 43% of our workforce are over 50. And about a third of our workforce, I've said already, are in the first 5 years of qualification. The remaining, that middle bit, in their sort of 30s or 40s typically, is around 20%. We've got a bit of gap in the middle, and it's a consequence of austerity. But over time, if we can keep these people, then we'll smooth out that issue. But the problem, so I've said 43% of our workforce are over 50. So Richard Atkinson wrote to me recently, chair of the Law Society, and told me that 58% of duty solicitors are aged 50 or over. So I'm 43%, he's 58. So we've got a problem generally that the legal profession practicing criminal law tends to be at the upper end. And so we've really got to address this problem of attracting people in.
And just going back to the specialist prosecutor role, you said that you're looking at whether there needs to be more of them. I think senior Crown prosecutors can be at the senior Crown prosecutor grade for years, decades even, without getting a specialist prosecutor role. And I know you said that a lot of them go to casework division, central casework division, because that's where the specialist prosecutor roles are. And I'm looking at the figures, and it says 25% of legal staff in the East Midlands have less than 2 years experience. The East Midlands was my area originally, before I moved to a central casework division as a specialist prosecutor. So one of the problems in the East Midlands was that there weren't any specialist prosecutor roles, so everybody moved to the central casework division. So have you got a strategy in mind for that? I think there might be specialist prosecutors in the East Midlands, for example, now, 1, maybe 2. But is that something that you would look at to keep staff in regional areas?
I think it's a very fair point, and there are a few specialist prosecutors dotted around the country, but you're absolutely right, of course, and the majority are based in headquarters, which, by the way, doesn't mean necessarily London. Our headquarters is dispersed around the country, and it's something that I would like to look at. I am sort of concerned around the different perspective on this, the balance between specialist prosecutors and SCPs. But I'm wholly committed to the idea of giving people a career-long experience in the Crown Prosecution Service. I mean, there are a number of different roles that you can perform, clearly, but people do want to progress. But of course, there are additional costs to creating extra roles, and so that's something we have to be mindful of. I'm very keen on improving our efficiency, and one of the reasons I need to do so is because resources are very tight. So whenever you create new roles which have a cost attached to them, you have to look at that very carefully.
Can I ask one more question? Yes. It's slightly different. It is on resourcing, but it's slightly different. It's relating to the advocacy strategy.
Oh, yes.
Because I think a large proportion of money is spent on outside counsel, but I know you have legal traineeships in place now in the CPS. What's your current advocacy strategy going forward?
I'm really glad you've asked me that question, because I was hoping to find an opportunity to talk about this. We have developed an advocacy strategy which involves a career path from pupillage all the way through to QC. There's one particular innovation I've introduced this year, which is this. Until September this year, if you did a pupillage in the Crown Prosecution Service, and we had 47 pupils, we were the largest pupillage provider in the country by a very, very considerable margin. If you wanted to undertake a role as Crown Advocate, which is our in-house advocacy service, you couldn't qualify into that. You had to do a period as a Crown Prosecutor reviewing cases, and then you had to make an application to be a Crown Advocate. The consequence of that was that we were losing about a third of our pupil barristers on qualification because there's so much work out there. So I've introduced a change which has taken place from September this year, which means that pupil barristers can immediately qualify as Crown Advocates. And it's meant that we've retained 90% of our pupil barristers, as against 66% or something in previous years. I need to say that this is strongly supported by the Bar. The chair of the Criminal Bar Association is a former Crown Advocate, and they recognise the need for this. That's phase one, and obviously that will continue. Phase two is to give our existing experienced colleagues the opportunity to transfer and become Crown Advocates, and we're hoping to roll that out next year. By doing this, we're going to significantly increase the number of Crown Advocates, and we're going to address a shortage of advocacy generally in terms of covering our cases. So we're going to close that gap, which means that there will be fewer ineffective hearings because there isn't an advocate available. But the other advantage of deploying Crown Advocates is that they are decision makers. So I'd like them to be doing these PTPH lists. The PTPH, I mentioned it before, it's the first substantive hearing. We hope very much that courts will brigade lists so that you'll have a whole load of those. If we can deploy a Crown Advocate, as we often do, they're in a position to make decisions on the day. A member of the self-employed bar has to get instructions, but they can make decisions. So there are huge advantages around this. May I say, I've already referred to the violent disorder over the summer. The majority of those cases were covered by our own Crown Advocates. And obviously, they were able to make decisions, but also it enhanced the communication between the CPS and the person in court, because they were one of our own, and that speeded up justice. So this is something new. I think it's important. It is backed by the bar, and it's a consequence of the fact that there aren't enough members of the self-employed bar who can service our cases. And so, as I say, it's something that has their support.
Thank you. We're going to have to speed up questions and answers. If we're going
Sorry.
No, it's all fascinating stuff, so I'm reluctant to interrupt. But had Sarah, and then I think Warren was thinking, yes. Yeah.
If you don't mind, you mentioned that in Manchester at the moment the caseloads are 200 per person. How does that compare to the rest of the country? And I know that in Manchester there has been specific historic case reviews. There have been a lot of problems in Greater Manchester Police that I suspect may play a factor here. So to what extent is this a CPS staff shortage, or to what extent is this a localised specific police issue that obviously is now having CPS impacts?
It's a combination of both, really, yeah. I mean, I think the average caseload, and if I'm wrong on this, I will write to you, but I think it's around 150. So 200 is obviously considerably in excess of that. And can I just say about receipts, that obviously we welcome the fact that the police are being so active and they're arresting people and sending cases in our way. The issue for us is having enough people to be able to service this. 200 is unsustainable. There's been a big turnaround in Greater Manchester Police as a result of the excellent Chief Constable there, Steve Watson, remotivating his colleagues. They've come out of special measures. They're being much more effective. But there are issues around the quality of investigations, which we are addressing with them. We've talked about this. The quality needs to improve because we're having to do a lot of rework of cases that come in. So it's really a combination of local factors like that, but the national picture is a growing number of receipts.
How many cases do you think a prosecutor can effectively manage?
Gosh, when I began my job, 120 was quite typical as a number that was given to me. People felt sort of quite under pressure there. It's something that I am sometimes asked. I'm a little bit reluctant to put a number on it because what I'm really focusing on is doing these cases better, doing investigations better. I've talked about our efficiency project, so I won't go on about that anymore. But one thing I haven't mentioned already, which I think is worth mentioning, there's too much churn between ourselves and the police, too much back and forth. I talked about KPIs earlier, and I said there's too much process. So we've got this 28-day limit in which to respond to a pre-charge decision. We meet that target if we send back an action plan, i.e. we're not ready to charge, but here's 15 points that you need to address. We've now put a cap of 2 on those action plans. You can't send out another one without permission of a senior colleague, because if you get to that stage, it probably means there's a fundamental misunderstanding between you and the police officer that can only be resolved through a conversation. That's been well received. It's implemented across the Crown Prosecution Service, and it is promoting better dialogue. It's just an example, I think, of, coming back to your question as well around pressure, if we can be more efficient in the way we manage investigations and then we deal with our casework, we can actually reduce the pressure on our colleagues and we can actually solve this issue of delay. So that's what I'm focusing on. I am often asked about the ideal target. Trouble is, if I said the target was 120, the reality is that we've got more cases than 120. So what am I to do? if the Treasury doesn't give me money. So what I can do is help to make us more efficient.
I suppose the flip side of that, though, is that if we've got trials collapsing all over the place and a third of them are because the CPS aren't ready, then we're in a chicken and egg. Until we establish what actually people can actually do, we will keep having things falling to pieces, and then that creates further backlog, and we just go round in this circle. So I suppose another question would be, in private practice, on average, how many cases, and I appreciate if you were doing financial crime, you would have had a smaller caseload, but on average, in a criminal private practice, what would you expect caseload to look like?
Well, I can only answer from my own experience, but I was in a firm where we were privately paid, and I don't think that will be a relevant figure, because we were paid to put the time into those cases. I suspect in a legal aid firm it's very similar to the situation in the Crown Prosecution Service. I mean, of course you're right, but the way I'm trying to address the problem of just going round and round doing the same thing over and over is to stop doing the same thing over and over. And I've already talked about a number of initiatives that we're taking in order to actually deal with those problems. Obviously I want more money, and that means I can get more people, and I will continue to ask for more money. And actually I should say at this point that we had a reasonably good settlement in phase one in recognition of the particular pressures that we are subject to. Because we can't control the number of cases coming in, and we can't control the backlog. We're right in the middle. But I think the other side to this is that we need to do better to be more efficient. And when I say we, I do mean us in the CPS, but I actually mean the police and the court service as well.
Yeah, thank you, Director. Excuse me. Hopefully I'll be able to ask these questions quickly in light of the information you've already given me, so I'm not going to ask all the questions that I had intended to ask you. But looking specifically at RASO cases,
yes.
Now those cases have increased quite considerably over the last few years, and I know that you've recruited 194 specialist staff, which is I think an increase of 44% since April 2021 into RASO. And you've mentioned that you've got this scheme now of having Crown advocates working on RASO cases. I understand that part of the problem that was faced by the CPS was not having enough prosecuting counsel and not having enough defence counsel. So with Crown advocates, hopefully you'll be able to solve the problem of not having enough prosecuting counsel. Just a couple of questions on that. Is the idea, if remuneration is a reason why you've not had counsel dealing with these cases, is there going to be a plan of paying these Crown advocates a higher figure because they're specialist lawyers specialising in very serious cases? And how will you deal with the issue of cases being ineffective because you don't have defence counsel available to deal with those cases?
Thank you. So in relation to Crown advocates, they do all types of work, not just rape cases. So it will make a difference, but it won't be the answer. In terms of remuneration, we've actually increased fees for the self-employed bar in RASO cases by 41% over the last 4 years. There has been an issue with the number of advocates from the self-employed bar able to do these cases, and there's been a certain amount of publicity about this, which is you're obviously alive to. We've taken another initiative in the last year which has made a considerable difference. At the start of the decade, there were 650 people on our RASO, that's Rape and Serious Sexual Offences panel. As a result of an initiative we took this year, we've increased that by 37%. So we've now got 912 people on the RASO panel. That's a huge difference, as you'll appreciate from the numbers. It wasn't because we increased fees. It's because, at least temporarily, we've reduced the requirements. So you no longer have to make a written application. You no longer have to provide a referee. You do have to do the training. And just taking away that bureaucracy has encouraged people to join the panel. So obviously I'm extremely pleased about that, and it's been particularly noticed in the southeast. I'm not saying it solves the problem, but it's going to go a long way towards dealing with that. In relation to the defence, I'm afraid it's not within my area of responsibility. I absolutely recognise that the pressures on criminal barristers in terms of pay and rewards and so forth. I will always be one of those people advocating for more money, but money isn't in my gift.
So, with the steps that you are taking, will your efforts be in vain because of defence counsel not being available, or do you think you'll still be able to make a significant impact with being able to have sufficient prosecutors?
Well, I absolutely take the point. What I am doing is addressing what I can in my power, which is that some cases couldn't take place because we couldn't find an advocate. I mean, every time I used to go around the areas, obviously I still am doing that, people are making 40, 50, 60 calls to chambers to find someone to cover a case. What I haven't been able to do through this, however, is to increase the overall pool of criminal advocates. I mean, I've sort of increased the number who are willing to do rape and serious sexual offence cases, but the overall number hasn't grown. So I can't say I've solved the problem. Generally, I've just made some change. On this question of parity, I think it's wrong that, as a result of the bar strike, the defence bar got an increase of, I think, 15%. And then, of course, that disadvantaged the prosecution. So some months later, we got an increase of 15%. Going forward, obviously it makes sense that, the legal aid agency and ourselves, the powers that determine who gets paid what, we work in tandem so that we can increase rates simultaneously, and that's something I intend to do, so we don't get out of kilter.
We have been talking about caseloads, and you mentioned that typical caseload of a RASO prosecutor was 200, and obviously...
So that's a typical caseload generally.
Generally, sorry.
For a RASO prosecutor, in fact, it's 37. Sorry to interrupt.
Sorry, I beg your pardon. Yes, that's right, 37, yes. So, is 37 the kind that you would recommend, or do you think it should be less than that?
I think it should be less than that. Again, for the same reason as I gave you, I'm very wary about settling on a number. But it's a considerable increase from where we were before, and that's a consequence of the fact that we've got considerably more cases coming into the system. Just to give you the figures, 152% increase in police referrals since 2020. Suspect charged gone up by 168%. So the volume has increased, significantly. What I want to do, sorry to come back to this, is for us to be more efficient. We've done a huge amount of work on rape, and that has generated an increased number of referrals. But another thing that I've instituted since I've arrived is a prosecutor-led end-to-end review of the way we deal with rape cases, looking at every stage to see if we can do it better. And I'm hoping that a consequence of that is that we will improve the way we do these cases, and that will reduce pressure.
And just a final question on that, Director. RASO cases, by their very nature, if I can, for want of a better description, they can be horrible cases, can't they? Yeah. Because you're dealing with serious offences, and I mean, I worked as a personal injury lawyer, and we had training as to how to deal for our own well-being with such cases. So what kind of support do you provide to RASO lawyers as far as their well-being is concerned, managing stress and so forth?
Well, first of all, can I just recognise exactly the point that you make? Doing these cases day in, day out is enormously stressful for individuals, as of course it is for everyone caught up in this. So we have a national operating model for dealing with rape cases, and part of that, a strand of that, is around looking after our own people. We offer therapy, counselling, one-to-one support, peer support, team discussions, and what we call professional reflective sessions, which really is quite similar to sort of clinical supervision. So I've got a figure here. So we, in the first year of this refreshed programme, because we rolled it out in the last year, 192 of our colleagues dealing with this work went through those reflective sessions, which involve supervision. So it's something we are very mindful of. But actually, of all those things, the ability actually just to talk to a colleague and having good supervision from the person immediately above you, that seems to be highly effective.
Thank you so much.
Thank you very much. Tessa or Sarah, did you want to come in, or Rasso?
Yes, if I may. I understand that it takes an average of 125 days from police referral of a rape case to a CPS charging decision. Would you agree with that? And
no.
Thank you. Would you like to correct me?
Well, yeah. So the latest figures are it takes, contextualising this, 317 days from a complaint through to a charging decision. In terms of our own, so this is when a victim comes forward and makes a complaint. At the point at which it comes to us, it's actually, you said 125, it's actually gone up, I'm afraid, it's now 130 days. Okay. But I wanted to mention the police figure, because you'll see from that it's almost 200 days before it actually gets to us for a decision. Mm-hmm. And there are various. I can talk. I know I've given very long answers, so I won't have it on. But I can give more information on that.
Can we? Yeah, thank you. That would be helpful, perhaps, in writing to the committee generally. Yeah. But can I just focus on your bit of it?
Yes, of course.
And shall we talk about that a bit?
Yes, certainly. Yeah. Well, that is the average. What I think I should say is that the average is a consequence of the outliers. So very long cases increase the average. So actually the median for rape cases, the typical experience, is actually 2 days. Yes, 2 days. Yeah. So if you look at a table with the quickest decision to the longest, mm-hmm. then you get an average overall. But you take the median, it's actually 2 days. And actually, when I last looked at CPS Direct figures, they were making decisions in 35% of rape cases. And that probably goes some way to explain that median figure. So there are a lot of cases going through the system where we make actually rapid decisions. But obviously the average is the one I've given to you, which is 130 days.
Okay, very good. Thank you. So what is it? What is it that's causing it to take so long?
Well, it's
accepting that there's a 2-day median, but the others.
Yeah.
What's happening?
A lot of it's to do with the increasing complexity around these cases. I mean, rape cases in particular involve often a considerable amount of digital material that needs to be looked at.
Is that not the stuff that the police do? Am I wrong?
They do, yeah. So part of the reason police investigations take long is they need to gather, mobile phone data, other digital material, forensics, and so forth. But then that needs to be reviewed by us. And these cases have become much more complex in recent years as a result of that. A lot of it is around the fact that cases don't always arrive in the best order. So police file quality, although I do say to the police, can we start talking about investigation quality, because that's what we're really talking about. It is better with rape cases, but there's still considerable room for improvement. And so I'm afraid too often cases don't arrive where we're ready to make a decision, and so there has to be some back and forth between us and the police. And that's probably the primary reason. We want to get cases in a state that when we authorise a charge, we're in a position to serve a full file on the defence. And I've talked about that already. Mm-hmm. And so that does incorporate extra delay at the pre-charge decision time period, but obviously it does have advantages further down the line if we can get those guilty pleas.
Thank you. Might be quite useful to see your graph of where your
is. I'm very happy to write to you with that.
To Andrew, please, Andy, that'd be handy. And then, so I've got here the latest data published by the CPS notes that receipts for adult rape outnumber finalisations by a rate of over 2 to 1. So how worried are you by those figures? And does that suggest that success in police referrals is outpacing the CPS and the courts' capacity to resolve those cases?
Yes, it does. Yeah. Yes. I mean, it's this issue we've talked about already.
Yes.
It's receipts against finalisations.
Yes. Okay, so that's...
So, I mean, you'll know that in the government's Labour Party's manifesto, there were a couple of things in relation to this that they talk about. One is ensuring that every police force has its own specialist squad of rape specialists. But in terms of the courts, they're talking about having specialist rape courts. And obviously that's something that's under consideration. It doesn't involve me. But one observation I would make without saying whether that will or will not happen. I've talked about guilty pleas, and 70% of cases end up as a guilty plea. In terms of rape cases, it's 22%, which is a much lower figure. And this has relevance in relation to listing. So the Lady Chief Justice talked about the balance that judges have to strike with listing. Because there are so many crack trials, they have to overlist, because otherwise the judges won't be able to fill their courts. But with rape cases, you've got much greater certainty that what was put down as a trial will actually happen as a trial, because the number of guilty pleas is so low. So my contribution on this is that I think it should be possible in rape cases, whether or not we have specialist rape courts, perhaps to go down the route of more fixed trial dates, which give victims and witnesses, obviously defendants as well, greater certainty that a trial will take place. And if we can do that, then maybe we can give them, more priority. Just one other thing to say on rape cases, though. Although everyone wants to give them priority, the greater priority has to be given to the remand population. And there are 17,000 people on remand in custody, and that's one of the reasons there will always be a considerable delay, I'm afraid.
We're due to finish the session at 4:30. I don't know whether you have to rush off or whether you can give us a little time to compensate for our voting behaviour.
Of course.
Thank you very much.
Yes, I'm sorry, I didn't realise that time had flown.
Sorry, are you finished?
I'll give way to Josh. I think is going to have something, isn't he?
Do you? I thought, Sarah, do you want
Moving
to
on.
know your
I don't know. Oh, sorry. Go on.
You mentioned the differential between the 2-day median average and the over 300-day average. You said it's 133 days in RASO cases for a charging decision, but the median is 2. That must mean that some decisions are taking a very long time. Do you know what the longest outstanding is?
I don't, but I've already said I will write to the committee, so we'll be able to provide you with that information. But yes, I mean, you mustn't think I'm minimising the problem, because I'm not. It's something that is one of my priorities, is rape RASO cases. And that's one of the reasons I launched this end-to-end review of the way prosecutors deal with these cases, to try and address this issue. It is an issue. It definitely is.
Can we have breakdowns of the numbers within first 6 months, 12 months, 18 months, 2 years, and like how 6-month increments to however long the end number is?
I'll do my best. If we've got that capability, we'll provide that. Yeah.
Thanks.
Thank you very much. Can we go on to Josh?
Cool. Thank you so much. So my questions are on domestic abuse.
Yes.
Domestic abuse consistently represents a third of all the crime that you handle. And what we can see from the data is that the number of suspects of domestic abuse-related crimes referred by the police to the CPS has fallen from over 110,000 in 2017-18 to around 69,000 in 2022-2023. Are you able to shed a little bit of light on why you think this is the case?
Unfortunately, I'm not. I mean, what I should say is that we only receive, obviously, a much smaller percentage of cases that the police investigate. It's something I'm really interested in. I've been looking at data from MOPAC. This is the Mayor's Office in London dealing with crime cases. They've done a study on victim attrition in DA cases. And it shows, for instance, that there's a 67% attrition rate within the first week. So I think we need much greater understanding around why so few investigations that begin end up in the criminal justice system. But that study showed that we received 18% of those investigations. What I can say is that this is an issue that we in the police have been working really hard on. We've just launched what we call a joint justice plan on domestic abuse, and what we're trying to do is learn from the experience on rape. So we've already discussed the fact that in rape cases we've significantly increased the number of cases, and that's as a result of what we call a suspect-focused rather than victim and victim-centred approach, by which we mean focusing actually on the activities of the suspect, which may seem obvious, but in rape cases we were spending far too much time in the past looking at the victim's account and worrying about what might undermine the victim's account, and not focusing on the suspect themselves. And we did a lot of learning from that, including early advice. So we're applying some of those lessons to domestic abuse. And we've got a couple of 2 or 3 pilots underway to trial a different approach. One involves early advice, one involves telescoping down the timescales for investigations and us making a decision. And we just started that one in Merseyside, Cheshire. And then we're looking at another one whereby we give the police the charging responsibility. So I'm afraid I can't explain the drop, although I'm sure it's something to do with attrition, and I'd love to see a national study around that. But what I can say is that we're seeking to address the problem. And as a result of the work we've done already, we've seen a 6.9% increase as a rolling average in terms of the number of cases we're dealing with. So the trend is going upward.
And what work are you doing to loop in and communicate with victims and survivors of domestic abuse when it comes to those pilots that you're doing, say? Because, you know, there's clearly an issue of confidence in the system, and that includes confidence in the Crown Prosecution Service's ability to play its part in dispensing justice on their behalf. And I'm sure that there will be many victims and survivors who would be, I think heartened would be the wrong word, but would find some degree of hope in the fact that you're working on some of these issues. So how are you communicating that and engaging with them?
Well, the straightforward answer is we're not in relation to these pilots, because these are pilots around the police CPS interface. And so I will certainly take back that observation and ask whether we can engage victims, but that's the primary driver. But just to address your point and put it in a wider context, if I may, I think victim confidence is hugely important. At the moment, there's a division of charging between ourselves and the police, and on domestic abuse, we've retained the charging decision, unless there's going to be a conditional caution or some other out-of-court disposal. And it's an area of constant debate between ourselves and the police as to whether we should keep that responsibility. And the police say, if you give us the charging authorisation, then we can deal with these cases more quickly and we can deal with attrition. But going back to your point about victim confidence, the reason at the moment we retain the charging decision is because we want to look at the whole picture around domestic abuse. It may come in as a common assault, but is there evidence of controlling and coercive behaviour? Are there patterns of behaviour that we need to be aware of, which might result in more serious charges, but might also mean that a court needs to be approached to give a protective order of one kind or another, and we're piloting domestic abuse protective orders at the moment to actually protect the victim. The concern is that if a case comes in from the police and it's not in a good state and we have to discontinue the case, then we may never see the victim survivor ever again. And there are different studies around all this, but generally, I've read it takes between 20 and 50 instances of domestic abuse before someone picks up the phone and contacts the police. So if, having had the courage to do that, we then let them down and they never come back, and that's a matter of real concern, because we know that domestic violence cases involve an escalation of violence often. So that's the debate we're having. And so I'm not minimising your question around victim confidence. It's at the heart of what we've got to do in the future, I think, to carry victims with us, give them the confidence to come forward, knowing that their cases will be dealt with well.
And when you use the phrase, some cases come to you in a bad state, what does a bad state of a case look like?
It'd be, and I'm sorry, I'm using perhaps loose language, but what I mean is there isn't enough evidence there to enable us to make a charging decision. And so you either discontinue the case or the police need to get their skates on very quickly in order to get the case back on track, bearing in mind that once you charge a case, you're in the court system, you're subject to all the timescales that the court system involves. So that's what I mean by that. I think one other thing I should say about that MOPAC study, really interesting study, it showed that of the cases that we did take forward, a third of them were evidence-led, by which we mean without the support of the victim. So attrition in domestic abuse cases is very high for understandable reasons, and often to do with, I'm afraid, the abuser. We don't always need them to be providing their support. We took a case, we were taken to the High Court in a case called Barton recently, in which the complaint was that we weren't using the evidence of the victim, but we had the body-worn footage from the police officer which showed the injuries, showed the recent complaint. That was enough to enable us to prosecute. And so we're working with the police as part of the Joint Justice Plan on encouraging them to switch on their body-worn cameras as a matter of routine to capture that vital evidence.
I just had a clarifying question, if I may. You mentioned those pilots, which sound very encouraging. How are they evaluated? Are they evaluated internally? Are they evaluated by consultants or academics? And what's the relationship more generally between the CPS and academic research? Because that point about attrition studies, I know that there have been national level studies on attrition over the last 20 years, so I just wonder how the CPS engages with those.
Well, I'm not aware of those national studies on attrition. I'm glad to hear there are, and I'll try and find them, or perhaps you would be kind enough to write to me. In terms of the pilots, I'm sorry, I haven't got that level of detail in my head, but we've got lots of data which enable us to measure the effectiveness of them. So we've already got data on the timeliness of investigations and decision making. So we're telescoping down the timescales around that. We'll be able to look at the impact of that on overall effectiveness in terms of convictions, early guilty pleas, and so forth. Equally, if we provide more early evidence, which is one of the other pilots, will that mean that there are fewer action plans because we're able to make decisions because we get a product of the investigation which is in a good state? So I will take back the question whether we are using external evaluators, but we have got lots of data that enable us to evaluate already, I think.
Thank you. Next we go to Alex Burrows-Curtis.
I haven't finished on mine yet. You spoke about common assault as an offence that's often very closely associated with domestic abuse and domestic violence. And sat in the very place where you are, but a couple of weeks ago, we had Lord Timpson and two officials speak a little bit about this. And I asked about the loophole that exists, in my view, around the SDS 40 scheme. And, some abusers are being let out early because they have convictions for common assault, which masks their abuse. And when pressing them about how we might close this loophole, one of the responses was, primary legislation might be required to help address that, whether that is a new offence of domestic abuse or domestic violence or whatever that might be. And I'm keen to understand from your perspective that should such a proposal be advanced, what might you see as potential unintended or unforeseen consequences? And do you think that a new offence would be something that would be helpful when it comes to delivering justice?
Domestic abuse cases?
Mm-hmm.
I'm not aware of a gap, I should say. I mean, if I can come back to your example around common assault, it goes back to what I was saying about our charging. The reason we retain charging, it's because we want to see the complete context about if something comes in as a common assault, the various questions that we will ask, or actually the police are supposed to answer when they send the file, to enable us to understand, is this a one-off incident, or is there a pattern of behaviour here that needs to be addressed? Not only in terms of the criminal investigation, but as I said earlier, protective orders, for the court. So I suppose my answer to you around the individual who's freed because they were in jail because of common assault, but actually they were a domestic abuser, would be the system failed there because we really should have caught that. That's the whole point about giving us that responsibility. I don't think we lack tools around domestic, and there have been a number of offences that have been introduced over the last few years. Controlling coercive behaviour is one, non-fatal strangulation is another. So I think we have been given the tools. I think the other thing is we're piloting domestic abuse and protection orders. They're quite wide-ranging orders. They can be imposed on conviction or acquittal. And so the courts do have quite wide powers, actually, even if someone leaves the court without a conviction. So more than happy to look at this issue, but that's my top-of-the-head response to a question that I hadn't prepared for, if I might say so.
Well, it'd be good to follow up with you another time on that, because I've certainly spoken with campaigners and with organisations in the sector that do believe there is a gap, that do believe there is a loophole, and that a common assault conviction is not appropriate for a number of the folks that have it now.
Yeah.
And the STS 40 scheme is an example of that problem in action.
Yes, I see that.
Thank you very much. Alex.
Thank you, Chair. And Director, I just want to touch a couple of questions on the treatment of victims, which actually has infused a number of your answers to the committee.
Yeah.
And I think go probably to your point about outcomes versus process. So one thing you started to touch on really in response to one of the previous questions about the impact of delays in the criminal courts having on victims. You've talked about confidence to come forwards, the attrition that can come from that. I don't know if there's anything else you'd like to add on that, but also in terms of the impact on defendants and their approach in these cases.
So the impact of delay?
Delays, yeah.
Yeah. Yes, well, I briefly alluded to that right at the beginning. The National Audit Office did they published their findings earlier this year around the remand population. They found that 35% of people held on remand ended up not in custody, either because they were acquitted or because they were convicted but given a non-custodial sentence. Now, obviously, I appreciate that one of the reasons they might have been given a non-custodial sentence is because the time they've spent in custody. But that's not going to be the reason in every case. The reasons why someone would be remanded in custody are to do with the Bail Act, not to do with, and the reasons for withholding bail, and not to do with the appropriate sentence at the end. So defendants suffer from delay, and I have also alluded to the fact that they take advantage of delay. So it is a very mixed picture, I think.
And sort of further to the kind of outcomes and process point that you were talking about earlier, in December last year there was a report from the Criminal Justice Joint Inspection about the kind of competing high workloads and demands of CPS staff meant that the appropriate time and attention perhaps was not being brought forward at every stage of a case in respect of the kind of interaction and support for victims, and there was a focus perhaps on complying with the letter of the Victims Code rather than responding to individual needs. Yeah. So I wonder what, if any, comments you've got on that and how confident you are that sort of has altered and that the CPS is sort of in a position to provide an improved service going forwards in that regard.
Thank you. Well, there's a number of aspects in which we're dealing with that. First of all, in terms of correspondence, I mean, our correspondence was defective. It was insufficiently empathetic. We've done a lot of work on revising our templates around this, but more importantly, training our staff to produce much better standard in terms of our correspondence. Our correspondence at present is sent out when we're altering or dropping charges. We're actually piloting making contact with victims. It could be through correspondence or their preferred method of contact when we actually make a charging decision. so that we can explain about that decision, about the process going forward. It's a pilot in a couple of areas. We'll obviously get feedback to see if that improves confidence. More generally, in relation to rape and serious sexual offences, we're doing quite a lot of work in this space. We've recruited over 40 victim liaison officers across the country to be a single point of contact for victim survivors of rape. And they make that contact from the point of charge, and from that moment onwards, that individual can contact us at any time to ask questions about the process, where we are on the timetable and so forth. And we will set up a pre-trial meeting, if that is desired, which will involve members of the prosecution team. So we're putting a lot of resource into that. I mean, that's an average of 3 victim liaison officers per area, but in fact what we do is we distribute these individuals according to the size of the area and the volume of the work. I'm fairly sure it's going to improve victim confidence. If we can show that, and if we can show that it reduces attrition, then I should be making a bid to the Treasury for more money to enable us to do more of that. I should say that we work hand in hand with witness care units, so that the police have a responsibility for being in contact with all victims and witnesses. And so this programme of interaction has been worked out very carefully with the police to make sure that we're not duplicating and also that we're not confusing people. But as I hope you'll see from what I've said, we're doing a lot of work, and we've got a central team actually that's coordinating all this and providing guidance.
Just very quickly, just in terms of showing that, how are you going to kind of scrutinise that? What are your metrics or measurements against going to be?
We're getting feedback, and we're getting direct feedback from victims through questionnaires, through surveys, through focus groups. We've also instructed some outside consultants to evaluate the project for us. We also have victim reference groups. One is focusing on rape and serious sexual offences, another on all other types of crime. They have, past victims on these groups, and they're enormously helpful. They've helped us with the drafting of the letters that I was talking about. They've given us quotes about their experience, which then feeds into the training that we give our staff. And so enormously helpful, and an example of improving the sense of communication with victims.
Thank you.
Thank you very much. Now, sadly, I'm going to have to postpone some of our matters we want to discuss to a future meeting, or possibly to put in writing. But so I'm going to move on towards the end of the session. There are a couple of areas I did just want to touch on in the last few minutes, on disproportionality and international work. Just before I do that, Mike, did you have anything else you want to say in relation to the riots and disorders of summer?
I have one question, if that's okay. Is there time for that? Yeah. Let me just get down to the question. So, as we know, the criminal justice system's response to the riots was well resourced, and you spoke about that earlier. Could you give an indication of the level of resources that was required to achieve that, please?
There is a figure somewhere, because we asked the Treasury for extra money to provide for overtime and so forth. I'm afraid I haven't got that to hand. What I can say is that during the period of the disorder, we had an additional 100 prosecutors on standby to make charging decisions, working out of hours and at weekends. So obviously we did pump in extra resource. There will be a figure attached to that, but I'm afraid I'm not in a position to give it to you. But I'm very happy to write to you and capturing some of the other things we've been talking about, and I'll add that to the list.
Thank you. And if I could just touch on a similar but not the same issue. Since the Hamas attacks in October, we've seen anti-Semitism in the country rising, Met Police recorded 1,350% rise the week after the attack. Across the Jewish community, confidence in the CPS to prosecute and ensure proper sentencing for perpetrators is low. Why do you think this is?
Well, I don't know why that is, because our conviction rate overall is relatively high. It's actually, our overall conviction rate is around 82%. In connection with hate crimes, it's 85%. And we prosecuted, in the year to June this year, 13,307 cases. Going back to last autumn, we saw a 10% increase in the number of charges in hate crime, driven by increases in racially and religiously aggravated hate crime. So we saw more cases coming into the system, almost certainly as a direct result of the disorder arising out of those very sad events last autumn. We do engage closely, actually, with forums for both Muslims and Jewish people. We've got good relationships with them, both nationally but also locally. We have staff who are dedicated to community engagement. So we do have good dialogue, but I absolutely understand the sense of fear and insecurity for Jewish people last autumn and during the disorder this summer for people from ethnic minorities. What we have to do is show that, and because we deal swiftly and effectively with cases such as this, will improve their confidence. And I know your question was in relation to the events of last autumn, but in relation to the violent disorder this summer, we actually did our annual survey of public confidence, and we increased confidence by 5 percentage points. It so happened that the period of the disorder coincided with our survey. So I think it does show that if you can demonstrate that you will deal swiftly, effectively, robustly with cases, it will improve public confidence. And as I say, I do believe that we did respond last autumn in terms of the numbers of cases that we dealt with.
Thank you. Thank you. Orinder.
Director, can I please ask you a couple of questions about your research into disproportionality?
Yes. Yeah.
In your charging decisions? Excuse me. I have read the letter that you sent to the chair of this select committee on the 27th of November, and I have to say that it was disturbing to read that the research published in February 2023 told you that ethnic minority defendants were more likely to be charged for a comparable crime than white British suspects. And your letter also confirms that you couldn't say anything about why the disparities were there, but you carried out further research, and even then you suggested that the underlying causes were complex and does not point to any one clear driver for disproportionality. So a couple of questions I wanted to ask you, Director, was, is it a clear case of unconscious bias? And if it isn't, what further action are you going to be taking in response to the findings that you've got so far? And how are you going to assess that in the future that disproportionality will not take place?
Yeah. Well, thank you for that question. I have spent many hours on this because it's a matter of very considerable concern to me. We did undertake, so we did the initial research, the Leeds research, and then the further research we did was trying to understand why this disproportionality was arising. And we looked at all sorts of issues around age, bad character, previous convictions, and discounted all of them. I mean, it came up with a nil return to explain where we got to. There were two things, however, which did stand out from the research. One was in relation to the use of language. So we used external consultants to actually look at language used by the police and ourselves in reviewing cases. And there was a noticeable difference in terms of the language. It was sort of more direct in relation to people with an ethnic minority background, and in some senses more violent. So that was one thing we noticed. Another thing we noticed was that the disproportionality, although it affected every area of the Crown Prosecution Service, it was most noticeable in areas which were least diverse. So in London, for instance, which is very diverse, there was disproportionality, but at a much lower level. The other thing that we uncovered was we did a survey of our prosecutors, and understandably, I think, but there was some resistance to the idea that there was disproportionality. The only explanation I think that makes any sense, if I say so, is unconscious bias. I've not ever come across, I'm sure there must be overt racism in the criminal justice system. If it happens in the Crown Prosecution Service, it's a sackable offence as far as I'm concerned. But I think there must be unconscious bias. And that's what we're working on in terms of the way we are responding to all this. We're going to be hoping to use AI on this question of spotting like trigger words to alert prosecutors to the existence of the impact of language. I'm going to be putting something to the Code for Crown Prosecutors which specifically alerts Crown prosecutors to the existence of disproportionality in the system and to be on alert for it. And I want to do that because the Code for Crown Prosecutors, it's like part of the DNA of a prosecutor. It's a code that is really, really important to us. And when we did our survey, our prosecutors said, no, we follow the code. So my answer is, we'll change the code. And in terms of looking at whether we're doing anything about this, we're going to constantly monitor this. So the sort of data set that Leeds University used is now part of our system, and we'll be able to carry on the analysis going forward, and so we will be able to monitor the impact of our action plan to see if we're making a difference. And if we're not making a difference, we'll try something else in order to make sure that we're cracking down on this. So it's not a one-off project. It's now part of all the performance issues that we look at going forward, if that provides you with some reassurance.
I start a specific on that, which is that one area where there have been concerns about racial disparities on charging is joint enterprise offences. What have you been doing specifically in relation to that? And what have you been doing on joint enterprise in relation to charging in cases where there is seen to be no significant contribution?
Well, we undertook a study around joint enterprise, and we did find that there were some disparities, but we also concluded that the sample wasn't large enough to be able to draw any conclusions from that. So what we are doing is we're putting in place extra mechanisms to supervise around these cases. We've identified joint enterprise as a specific category, and following on from the pilot that we did, which is now concluded, but with the continuance of this work of extra attention being given to these cases, we're going to produce a report in I think, May next year. So it is on our radar, and I'm sure when I next come to see you, I hope we'll have published by then, and I'll be able to talk in more detail about this. But this issue around people on the edges of these cases is something that we are alert to.
What does that mean in practice? That is within guidance, or that is within the plans that prosecutors look at? That's one of the factors they need to look at?
Yeah. The reason that we had the pilot and the reason we continue to give attention to this is to make absolutely sure that we're making the correct decisions around the evidential test, but also the public interest. in connection with people, in particular more on the periphery of these cases, as to whether they should actually be in the system at all. But I can't, I'm afraid, give you any conclusions yet, because we're sort of in the middle of it.
I understand. Sorry.
Just Director, having accepted that it must be unconscious bias, which accounts for this, will you be providing extra training to your prosecutors on unconscious bias?
Yes, we will. I want to do more than simply unconscious bias training. I mean, I've done unconscious bias training. But we're going to do some further work to actually understand what works best. I mean, this is an area which is very unsettling for lawyers in the Crown Prosecution Service, and there are many lawyers around this table, so I'm sure you'll understand this when I say that we like to think we're making objective and dispassionate decisions, and so if we're told that we're not, it's something that goes almost to our integrity. But the way I've explained it, starting to explain this to colleagues, we did some research earlier in the year on myths and assumptions around rape cases, and we published this research actually, so you can look at it online. There's a lot of misconceptions around rape, and in particular around this issue of consent, and particularly in this age group of 18 to 24. So it's not unusual for a youngster to think that because they've swiped right on Tinder, they've given consent to sexual intercourse and there's no going back. Now, I mention that to my colleagues because as a result of that research on rape, we've introduced training around myths and assumptions so that our prosecutors make the correct decisions. And this is another example of where, perhaps, stereotypes are in play that we're not even aware of, but we need to be conscious of so we can address. So I'm sort of trying to normalise it in talking to my colleagues. So we're doing it in rape, we're going to do it in relation to disproportionality as well. But I'm really determined that the work we do isn't simply ticking a box. You've done unconscious bias training, sorted, because I don't think that will be enough. It will help, but I don't think it will be enough.
Really fine. Yeah, I need to go to Lindsay.
Thank you. That's really important work. So thank you for that. I just lastly wanted to pivot a little bit onto a different topic, which is your international strategy. And I just wondered how many international liaison prosecutors you have deployed in country at the moment?
We've got 15. 15.
Because that's a reduction. It was 27 in 2019. Is there a reason for that?
There is, yes. I mean, the total number of liaison prosecutors is 18, so we've got 3 roving prosecutors. It's based on an assessment of the amount of work in some of these countries. So we look at the level of casework, and we have to look at whether we can justify the costs of having someone in country as opposed to alternative ways of having effective liaison with our counterparts in other countries. And I'm afraid as a result of looking at the costs, bearing in mind that we're severely financially constrained in the CPS, we have made those decisions to reduce numbers.
And the roving prosecutors are based in the UK?
Yes.
And is it important for them to travel to countries overseas? Yes,
it is. It is. I mean, the idea is that they will get on a plane, and if there's a need for a face-to-face conversation, then they'll be able to have it. Yeah.
And is that to build up relationships with overseas contemporaries, or what would the strategy be there in terms of what would be the need to go over? Yes. Well, the whole. As you will fully I know because it's one of your previous roles, so I know you're very expert in this area. Yes, I mean the whole point is to build relationships with our counterparts overseas, and that can make
an enormous difference in terms of giving priority to those cases that really do need that attention. Obviously, we build up expertise and knowledge about the way those countries work. It just so happens that one of my earliest jobs in the CPS was to set up the International Cooperation Unit. It was called that quite deliberately because there was one person, that was me. And we've obviously considerably expanded since that time. And we recognise the importance of relationships. I recognise that. I mean, there were a number of international bodies. There's the International Association of Prosecutors. Brazil was heading the G20 this year. They brought together all the Procurator Generals from the G20 together. So, I mean, this year I've been to Azerbaijan and to Rio de Janeiro to meet my counterparts. And obviously at a national level, I'm building up relations. Colleagues more junior to me, but still quite senior, are building relations as well. So it's not with their counterparts. So it's not just down to the liaison prosecutors in country. We have relationships with our counterparts at every level overseas.
But the operational relationships are important.
Absolutely, they are. And I think the roving prosecutors is our answer to the situation in which you've got a really important case, but you can't justify, the cost, which can be 200,000 quite easily, of having someone in country.
I think that the government has emphasised the importance of international cooperation to tackle irregular migration as a core plank of the strategy for dealing with that situation. And I think as a result of that, the NCA are recruiting around 100 new officers to be deployed out in country. So I hear what you say about the costs involved, but would you say that you're adequately resourced, or are you resourced based on the budgetary constraints that you have? What would be the ideal scenario?
Yeah. Well, we have been given extra money ourselves as a result of that initiative. And we are, well, first of all, keeping this under constant, advisement. And we can use that money to deploy people overseas. At the moment, we're going to use it in connection with domestic prosecutions. But we do have, we've got a specialist in France, as you probably will know, who focuses on illegal migration.
And that's now a rover post.
Sorry?
There used to be two in Paris, didn't
yes.
they? But I thought the Operation Invigor post was now a roving post.
You may be right. I thought they were in country, but in any event, they're dedicated to France, and we have prosecutors deployed in various European countries, including Turkey as well, which is one of those key countries involved, we think, in illegal migration.
The upstream suppliers.
The upstream supply, yes. So there's no lack of willingness to deploy liaison prosecutors, in particular in relation to that issue. It's simply a question of if we think that additional prosecutors will make a difference, or whether the existing prosecutors we've got have already built those relationships, and that's sufficient. It's not a question of money, though.
Thank you.
Thank you very much. And only way for me to thank Mr. Parkinson for all his answers, particularly for staying so late. And I apologise that we kept you. There were areas we didn't reach about relationships with the police, about disclosure, about economic crime. We may write to you about some of those if that's okay. I hope you've enjoyed your time before the committee. I do apologise again for being over time, over the 2 hours that we said. Thank you very much for your evidence today. And with that, I will close proceedings